I wanted to tell you thank you. You're doing a heck of a job. That's a direct quote from Diddy to the judge when the judge addressed him during the courses of allocution on today, day 29 of the Diddy trial, the final day for testimony in this trial. And I've got a lot to break down for you. I am Joe Neerman, aka Good Logic. I'm a New York attorney. Was practicing this very courtroom. I've been coming here down to this courthouse to try to break down for you how effective a job the state is doing, how good a defense we're seeing from the Diddy team, how effective a job the judge is doing, and the vibe of the courtroom. And today we had our final day of testimony. The state rested. We got an allocution from the judge of Diddy asking him whether or not he intends to testify. As expected, he decided to invoke his Fifth Amendment rights to not testify, did not take the stand. And in fact, we saw no witnesses from the defense. In lieu thereof, they presented exhibits. This is it's stipulated together with the state that certain exhibits will come in. I'll get into the nature of those exhibits. To me, what was the most interesting thing that came out of today, we started the day with the cross-examination and then a brief redirect of the summary witness that was presented by the state as their final witness, and most of the testimony that was going on there was kind of bland and a little bit all over the place on direct, and similarly so on cross, where there would be just instances of conversations or exchanges that happened that there would be question about, did they say this, did they say that, which really lack much context. And it's difficult if you're not looking at the chart, which we in the viewing room are not privy to see, to really glean much from it. Perhaps it has some more impact on a jury who is able to see this, the nature of this evidence. To those of us who were sitting in the viewing room, it was far less impactful. To me, what was more interesting was the application for a directed verdict of acquittal that was brought by the defense as expected at the close of the state's case. Now, under Federal Rule of Criminal Procedure, Rule 29, they have the right, and indeed it's likely malpractice if they do not exercise that right, to ask the judge to acquit Diddy of the charges that are brought against him on a basis that even looking at the evidence in a light most favorable to the state, that no reasonable jury could convict him for a charge or all of the charges as expected. They asked for all the charges. Why did I say that it's malpractice not to do it? Well, if you waive your Rule 29 application, that seriously jeopardizes your ability to appeal several issues down the road. So even though most of the time, the vast majority of the time, a Rule 29 application for a directed verdict is going to be denied by the judge, it is a necessary step for every defense counsel to invoke and bring up that application, which is an oral application, which we get to hear the arguments presented by the defense. The reason I find it so interesting is because it gives us a really good precursor as to where the defense is likely to go in their closing arguments and present their theory of the case. But in this stage, it's a free shot for the defense. If they lose on it, that doesn't hurt them at all. It's only a potential upside that they can hit a home run if they knock out one or more charges, because the judge agrees with them that no reasonable jury, even looking at the evidence in the light most favorable to the government, could convict him. And it's a free shot. Either the judge gives it to them or he denies it. As I said, 99.99% of the time it's denied, but it's a necessary step. And we got a really good glimpse into where the defense plans on going in their closing argument and what their theory of the case is. They spent a great deal of time attacking each charge. They attacked all 5 charges, and most of the time was spent on the RICO charges. And that's because if you look at the RICO charges, you need to establish that there's a criminal enterprise for the commission of various types of charges that are enumerated under the specific statutes. So first and foremost, they attack that there could not be a criminal enterprise here, that they describe an enterprise under the law as being like a wheel where you have your hub and your spokes and the rim, and people are sort of working in a particular facet to get, and they're all tied together by Diddy to try and effectuate a particular crime. So just in general, if you want to look at what the nature of the types of what criminal enterprises look like, each entity in that, from those different spokes there, they're supposed to know this is my role here. For example, I'm the one who's cracking the safe, you're the one who's taking care of the guards, you're the one who's doing the getaway car. Everyone has their different roles here to try and facilitate, to work together in order to try and effectuate a crime, even if not everyone doesn't know the other roles of the others. They're still supposed to know what's happening here. And the allegation that was raised by the defense is that you cannot have a criminal enterprise when you have these different employees who don't realize they either don't realize they're facilitating a crime in many of the circumstances here, and that you don't have the typical hub and spokes and rim that you would see in a normal RICO charge. Now, excuse me for a moment. After attacking the overall structure of the RICO charges, they also attacked and basically said, look, the reality here is if you go through the different crimes here, here's where we find that the government's case was lacking to establish various predicates, such as the drug trafficking or the with respect to the slave labor, or forced or coerced labor, or sex trafficking, and going down one by one, each one of them, why it is that they felt that there was lacking sufficiency to establish that in fact that there's this criminal enterprise engaging in racketeering, where they went through the obstruction, trying to point out that at the time that things are happening here, no one thinks there's a federal indictment that might be coming along, so they don't realize that they could be obstructing something, and there's not an effort and a mens rea, an intent for them to try and obstruct. And similarly, with respect to the forced labor, they hit on the fact that each of the people who purportedly were forced to engage in forced labor, whether you're talking about Christina Clark or Mia or these different individuals, all of them were free to leave whenever they want. And just because they felt they had to work abusive hours or put up with Diddy being verbally abusive or even physically abusive, they were all free to leave at any time. And if they're free to leave, you can't say it's forced labor. That's an employment dispute. And if you try saying that they weren't paid sufficiently because of lack of money or overtime or these other elements, these are your typical employment disputes which are handled under employment law that don't rise to a level of criminality and accordingly cannot help substantiate a RICO charge. With respect to sex trafficking, that they put aside and said we're going to come back to later. But I think it's interesting that they hit on the exact point that I was making, primarily about Jane, but they even brought it back about Cassie, and that relates to mens rea. Now, mens rea is a Latin term which refers to the intent. Even if the subject victim feels forced, even if they feel that they have no choice, if I don't do this, I'm going to lose the roof over my head. If I don't do this, I'm going to lose my relationship, and I need this for one reason or another. Even if they felt completely forced, if the perpetrator, the defendant, has no reason to realize that they feel forced and is not trying to force them, it's not his objective to do that, he cannot be convicted of the crime. Mens rea is a necessary element is a necessary factor to each element of the crime. And since it's a necessary factor, they said the government has done nothing here to try and establish that Diddy knew that Jane, for example, felt forced, that she felt compelled. In fact, they pointed out how we have one exhibit after another where all they're expressing is how much they're enjoying these sexual encounters, and accordingly you can't say, how is he supposed to know that they feel forced when all they're doing is telling him how much they love engaging these different encounters. Now, I have said that that's something that I certainly can see working with respect to Jane. And in fact, with respect to Jane, I'll come back to Cassie in a moment. With respect to Jane, the defense further pointed out that, hey, the government in their initial indictment, and then they had a superseding indictment, it was only the third indictment when they heard about the purported physical violence that happened on June 18, 2024, which is something they only learned about a couple of months ago. Long after they started interviewing Jane, she never told them that she was about this night of violence that allegedly happened on June 18, 2024. And even if she told it over in a way that frankly seemed to me to be compelling, the reality is that without that one element, there's no incident of violence between Diddy and Jane. That is the only incident we heard, and they say even if you believe her, and the judge in this context is supposed to look at the evidence in light most favorable to the government, to the government. So since the judge has to look at it that way, he say, well, I have to look at it as if I believe them. But they're claiming that even if you have that one-off incident, that cannot be trafficking. There's not trafficking in one incident. And they were citing case law to try and establish that it's insufficient to prove as a matter of law. If it's insufficient, that would be a cause for the judge to say, I can't allow a jury to mull this over and potentially convict him on something that's legally insufficient. That's why we have Rule 29, to try and say, I have concerns that maybe a jury will not understand the law, for one reason or another, convict him for other reasons other than complying with the law, if they're allowed to consider this. And that's why, if in fact there is a legal insufficiency, that's precisely the scenario where the judge is supposed to dismiss it. Now, and that's why this has to come up under Rule 29. That's why you must make this Rule 29 application. Because if in fact there is a legal insufficiency and you don't make the Rule 29 application, you cannot then come back to the appellate court and say, hey, as a matter of law, the jury had no right to convict him. Because the first thing they'll look at and say, did you raise this as part of your Rule 29 application? And if you didn't, you can't appeal it. You have to be appealing from the decision of the judge that this is sufficient as a matter of law. And then when he denies it, and in theory, if Diddy were to be convicted, then you can say that denial by the judge was wrong as a matter of law, and that's why this conviction by the jury has to be overturned. So that's what, now you have a better understanding as to how Rule 29 works and why it is that defense counsel it's malpractice for them to fail to make a Rule 29 application, at least in my professional perspective. And I'm sure that a lot of attorneys would agree that would be legal malpractice for them to fail to do that. After they finished their application, and they claimed that they brought the mens rea, not just with respect to Jane, but they also claimed that with all the messaging and things that they got from Cassie and all the statements from her, that there was no way that he could have mens rea to understand that Cassie felt forced. So they finished up, and then they said that the Mann Act violations that he's charged with, the interstate transportation for purposes of prostitution, that those two are that there was an insufficiency of establishing that Diddy was involved in those steps there, and accordingly that the judge should grant the Rule 29 application and that he should dismiss the charges. It is highly doubtful that the judge will. At the close of their application, the judge asked the government if they have any response, and they say, we rely on the case we presented here, that this case there's more than enough evidence here to establish that a reasonable jury could convict, and accordingly this application should be denied in its entirety. Now, at that point, we moved into the defense's case in chief, and they started with the allocution. The allocution was basically saying, that's where the judge turns to Diddy and says, hey, do you want to testify? And after conferring briefly with his attorney, and we have the classic exchange back and forth between judge and defendant, wherein the judge basically needs to lay out for the defense that it has to be his own individual decision, that he does not want to testify, that he's allowed. And he asked him, have you consulted with your attorney about whether or not you'd like to testify? And he said yes. In fact, he said considerable conversations. And he said, do you wish to testify? He said no. And he asked him if this is his own choice, and he said yes. And that, it's not up to his attorneys, but it's his choice. He said, under the advice of counsel, that I'm not doing it. And that made the judge pause and go back. He's like, it has to be your decision. This is not counsel's decision. This has to be your decision. Is it your individual? You alone decide this. Do you want to testify? And do you waive your right to testify? And he said, yes. that he's waiving his rights to testify. He asked the government if that was satisfactory, because the government is the entity that has to be concerned that if in fact the allocution is done improperly, in theory, that would open up a doorway for a defendant to say, hey, he wasn't properly allocated and accordingly wasn't properly informed of his rights, or didn't properly express his assent to waive his right to testify, and accordingly that could cause a necessity for a retrial. The government said they were satisfied with the job that Judge Subramanian did, and we were done with that. At that point, we took a short break before we got like a 15 to 20 minute submission from the defense of various articles of evidence, various text exchanges or statements with respect, and what we heard was a whole bunch of love bombing from Cassie that happened in 2012 and 2013, where she's sending long text messages that were read by defense counsel to Diddy, and where she's basically expressing how he's the love of her life and she's so lucky that she has him and she loves being in love with him, and on and on and on. And the interesting thing is, with the timing perspective, this is a year after the whole Kid Cudi incident. This is well into their relationship, and in those messages she also expresses her own regret for being difficult to put up with at times and being too childish, and promising that she's going to get better. And the objective that the defense is looking for out of all this is obviously for the jury to take from this that she, after going through all of these free calls for all these years, is still doesn't feel as if she's been trafficked. So that's likely why we got that. They closed out with a couple of other pieces of evidence where they're reading off multiple dates that various defendants who came in and testified during the course of this trial, whether you're talking about Christina Clark or Mia or Bana, these are different names that we've talked about during the course of this video series over the last month and a half, who have come in and testified and basically saying they came and met with the police on this many dates, and here are all the number of times that they came in without ever telling police that they were physically assaulted, or that Diddy said, I can kill you. And the point being that the defense wants the jury to draw from this is that those claims, which only came up later, may have been manufactured by those witnesses who made those statements, and they should be discounted if not disregarded, or in other ways impugning the credibility of those witnesses who testified to those facts on the stand. And with that, the defense rested. There was no rebuttal from the government, and we laid out here a schedule which says we will be off tomorrow, and that we will come in here on Thursday for closing arguments. Closing arguments are supposed to be 4 hours apiece, 8 hours total of closing arguments from the state and then from the defense. Oh my God, I don't know what Judge Subramanian was thinking when he gave them open season. I'm glad they didn't say they want 2 days apiece. They could have said whatever they wanted, apparently. He said, I'm going to give you what you want. And 4 hours, to me at least, seems rather extensive. Sometimes brevity is the mark of good advocacy, but apparently these attorneys, who I should say before I close out on this final day of testimony, the work done by the attorneys for the state in prosecuting these charges and the work done by the defense counsel was exceptional. It happens to be a pleasure to watch skilled attorneys do their thing, and they were doing their thing with a level of skill and precision. Yet sometimes they would miss their mark, sometimes there would be errors, but you're talking about a handful of errors over the course of a 6-week trial. It was really remarkable work by both sides. Judge Subramanian, I would tell you, did a pretty good job by and large. I don't have complaints with the work of any of the entities here. I think that once we get past the charges, which I mentioned several times, my issue with the charges that were brought here, and I have great issue with Maureen Comey and her team for the nature of the charges that were brought here. But once we're here in this courtroom prosecuting these charges, as expected, the state and the defense did remarkable work, and like most district court judges in a trial setting, Judge Subramanian did very fine work as well. I expect to be breaking down for you the closing arguments on Thursday, And if you like this type of thing, I urge you to please like, share, subscribe, hit that bell so you get all further notifications. I'm Good Logic. Till next time, Godspeed.